Panagdait sa tanang kabuhatan. I am Rhealyn Monsanto, BSA 2. My report for today was all about Title 15 entitled Foreign Corporations. So first, let us all define foreign corporations. According to the book, under Section 140, Definition and Rights of Foreign Corporations, it is one form organized or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after obtaining a license for that purpose in accordance with its code and a certificate of authority from the appropriate agency. So there are requisites in forming foreign corporations here in the Philippines. So first, it must be formed, organized, or existing under any laws other than those of the Philippines. And second, the laws of the country where the corporation was organized allow Filipino citizens and corporation to do business in its own country or state. So under Article 123 of the Corporation Code, now Section 140 Revised Corporation Code, it is stated in here that a foreign corporation must first obtain a license and a certificate from the appropriate agency, government agency, before it can transact business in the Philippines. Where a foreign corporation does business in the Philippines without the proper license, it cannot maintain any action or proceeding before Philippine courts as provided under Section 133 of the Corporation Code, now Section 150 Revised Corporation Code, which we will be tackling later. So, it is clearly stated that these foreign corporations have its own world in their business. It does not depending, their laws does not depending on the Philippine jurisdiction, but they should follow the rules of the Philippines, which is they can only transact business here in the Philippines after obtaining a license and a certificate of authority. So, what does it really means of doing business? To constitute doing business, the activity undertaken in the Philippines should involve profit making. So, if we will say that doing business, we can say that this certain person of this or this certain business or group or corporation is making profits. So in the second stanza, activities within the Philippine jurisdiction that do not create earnings or profits to the foreign corporation do not constitute doing business in the Philippines. So it is stated in there that it is clearly stated in there that activities within Philippine jurisdiction that do not earn profits cannot be considered doing business in the Philippines. So to connect of doing business, let us now talk about export and import of products. So an exporter in one country may export its product to many foreign importing countries without performing in the importing country's specific commercial acts that would constitute doing business in the importing countries. The mere act of exporting from one's own country without doing any specific commercial act within the territory of the importing country cannot be deemed as doing business in the importing country. So, otherwise, Philippine exporters, by the mere act alone of exporting their products, could be considered by the importing countries to be doing business in those countries. So, in this case, it will require the Philippine exporters to secure a business license to the importing countries where they usually export their products. So, in one case, a foreign company merely importing products from a Philippine exporter, a foreign company that merely imports goods from a Philippine exporter without opening an office, an agent in the Philippines, it is not doing business in the Philippines. So if naga-export lang ka og product anang nga country, then wala ka nagtukod didto, wala ka nag-rent og space didto, wala ka nag-rent og space anang nga importing countries, then naga-export lang ka og products, then we cannot consider it doing business inside that country. And we should always remember that by securing a license, which is a legal requirement to lawfully engage in business in the Philippines, the foreign entity would be given assurance that it will abide by the decisions of our courts, even if adverse to it. So, under Section 141, Application to Existing Foreign Corporations, it is stated in there that every foreign corporation which, in the date of the effectivity of this code, is authorized to do business in the Philippines under a license issued to it shall continue to have such authority under the terms and conditions of its license, subject to the provisions of this code and other special laws. I have explained this already. And in Section 142, Application for a License, a foreign corporation applying for a license to transact business in the Philippines shall submit to the Commission a copy of its articles of incorporation, bylaws, certified in accordance with law, and their translation to an official language of the Philippines if necessary. The application shall be under oath unless already stated in its articles of incorporation, and shall have the following. So these are the things we should consider in applying for obtaining a license. So first is the date and the term of incorporation, then the address, including the street number of the principal office of the corporation in our country, then the name and address of its resident agent, authorized to accept summons and process in all legal proceeding and all notices affecting the corporation pending the establishment of a local office, and the place in the Philippines where the corporation intends to operate, the specific purpose or purposes which the corporation intends to pursue in the transaction of its business in the Philippines, provided that said purpose or purposes are those specifically stated in the certificate of authority issued by the appropriate government agency, the names and addresses of the present directors and officers of the corporation, that is very important, and a statement of its authorized capital stock, and the aggregate number of shares which the corporation has authority to issue, itemized by class, par value of shares, shares without par value, and series if any, a statement of its outstanding capital stock, and the aggregate numbers of shares which the corporation has issued, itemized by class, par value of shares, shares without par, and etc. A statement of the amount actually paid in, and lastly, such additional information as may be necessary or appropriate in order to enable the Commission to determine whether such corporation is entitled to a license to transact business in the Philippines, and to determine and assess the fees payable. So those are the things we should consider when we are applying for a license in a business. So the next is the obtainment of a license prescribed by Section 125 of the Corporation Code, now Section 145 in the Revised Corporation Code. This section was in our book, and in summary, what's in this section 145 in the Revised Corporation Code. In summary, no foreign corporation shall be permitted to transact business in the Philippines, as this phrase is understood under the Corporation Code, unless it shall have the license required by laws, and until it complies with the law in transacting business here, it shall not be permitted to maintain any suit in local courts. And it is not the absence of the prescribed license, but doing business in the Philippines without such license, which debars the foreign corporation from access to our courts. So it is clearly stated in there what this section is meaning of Section 145. To proceed with, let's all tackle about meaning of doing, engaging in, or transacting business in the Philippines. So, no general rule or governing principles can be laid down as to what constitutes doing or engaging in or transacting business. Each case must be judged in the light of its own peculiar environmental circumstances. The true test, however, seemed to be whether the foreign corporation is continuing the body or substance of the business or enterprise for which it was organized, or whether it has substantially retired from it and turned it to another. So, not doing business. So, as a general rule, a foreign corporation will not be regarded as doing business in the state simply because it enters into contracts with residents of the state, where such contracts are consummated outside the state. In fact, a view is taken that a foreign corporation is not doing business in the state merely because sales of its product are made there or other business furthering its interests is transacted there by an agent, whether a corporation or a natural person, engaged in by the agent as an independent business. So I have already explained it, that what does it mean of doing business and not doing business. So next is the right of a foreign corporation to bring suit. The principles regarding the right of a foreign corporation to bring suit in the Philippine courts may thus be condensed in 4 statements. So you can find this in the book, page 499. If a foreign corporation does business in the Philippines without a license, it cannot sue before the Philippine courts. If a foreign corporation is not doing business in the Philippines, it needs no license to sue before Philippine courts on an isolated transaction or on a cause of action entirely independent of any business transaction. So the third statement is, if a foreign corporation does business in the Philippines without a license, a Philippine citizen or entity which has contracted with said corporation may be stopped from challenging the foreign corporation's corporate personally in a suit brought before Philippine courts. And lastly, if a foreign corporation does business in the Philippines with the required license, it can sue before Philippine courts on or any transaction. So, it is stated in there the right of a foreign corporation to when they can legally sue any if they only require those license of the or if they only has the requirements to in building their foreign corporations. The next is the doctrine of isolated transactions. So, foreign corporations, even unlicensed ones, can sue or be sued in a transaction of series of transactions set apart from their common business in sense that there is no intention to engage in a progressive pursuit of the purpose and object of business transaction. So, in section 143, which is an issuance of a license, if the Commission is satisfied that the applicant has complied with all the requirements of this code and other special laws, rules, and regulations, the Commission shall issue a license to transact business in the Philippines to the applicant for the purpose and purposes specified in such license. So, in there, it is stated that to when the Commission will issue a license to the applicants. So, next topic is the foreign corporation by laws effective in the Philippines, section 125 of the same code, now section 142 in the revised corporation code. So under this section 125 of the same code, now section 142 in the revised corporation code requires that a foreign corporation applying for a license to transact business in the Philippines must submit, among other documents, to the SEC a copy of its articles of incorporation and bylaws certified in accordance with law. Unless these documents are submitted, the application cannot be acted upon by the SEC. In Section 126, the Code, now Section 143 in the Revised Corporation Code, specifies when the SEC can grant the license applied for. Section 126 provides in part. So the next is the Section 126, which is all about issuance of a license. So under this section, it is stated that if the Securities and Exchange Commission, or the SEC, is satisfied that the applicant has complied with all the requirements of this code and other special laws, rules and regulations, the Commission shall issue a license to the applicant to transact business in the Philippines for the purpose or purposes specified in such license. So it is clearly stated in this section to when the SEC will approve the issuance of a license. So next is the Section 144, who may be a resident agent. So, a resident agent may be either an individual residing in the Philippines or a domestic corporation lawfully transacting business in the Philippines. So, in short, this resident agent is the one who will handle those legal process, or this resident agent is the one who will manage those papers with lawfully based problem. So stated in there that a resident agent is an individual residing in the Philippines, and he must be of good moral character and of sound financial standing. So second, a domestic corporation lawfully transacting business in the Philippines and must likewise be of sound financial standing and must show proof that it is in good standing as certified by the SEC. So what is the purpose of appointing a resident agent? For the purpose of accepting and receiving on behalf of the foreign corporation, first, notice affecting the corporation pending the establishment of its local office, and second, summons and other legal processes and all proceeding for or against the corporation. We should always remember that the appointment of a resident agent of a foreign corporation is revocable at any time at the instance of the corporation. So next is the Section 145, Resident Agent Services of Process. So you can only read this in the page 502 in your book, and there is this statement that as condition to the issuance of the license for a foreign corporation to transact business in the Philippines, such corporation shall file with the Commission a written power of attorney designating a person who must be a resident of the Philippines, on whom summons and other legal processes may be of the Philippines, on whom summons may be served in all actions or other legal proceedings against such corporation, and consenting the services upon such resident agent shall be admitted and held as valid as it served upon the duly authorized officers of the foreign corporation at its home office. So this stated the purpose of appointing the resident agents. So ways of serving summons. So ways of serving summons. When summons is served on a foreign juridical entity, there are three prescribed ways. So first, service on its resident agent designated in accordance with law for that purpose. Second is service on the government official designated by law to receive summons if the corporation does not have a resident agent. And third and last, service on any of the corporation officers or agents within the Philippines. So, purpose of summons. The purpose of summons is not only to acquire jurisdiction over the person of the defendant, but also to give notice to the defendant that an action has been commenced against it and to afford it an opportunity to be heard on the claim made against it. And we should always remember that the requirements of the rule of summons must be strictly followed, otherwise the trial court will not acquire the jurisdiction over the defendant. So next is section 146, law applicable. Law applicable. A foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules, and regulations applicable to domestic corporations of the same class except those which provide for the creation, formation, organization, or dissolution of corporation, or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members, or officers of corporations to each other to the corporation. Next is the general rule and exceptions. A foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules, and regulations applicable to domestic corporation of the same class. So there are also exceptions, except those which provide for the creation, formation, organization, or dissolution of corporation, or second, except those which fix the relations, liabilities, responsibilities, or duties of stockholders, members of the officers of corporation to each other or to the corporation. Next is the section 147, amendments of articles of incorporation or bylaws of foreign corporations. You can also read it on page 504. Next is section 148, amended license. A foreign corporation authorized to transact business in the Philippines shall obtain an amended license in the event it changes its corporation name or desire to pursue other or additional purposes in the Philippines by submitting an application with a commission favorable endorsed by the appropriate government agency in the proper cases. We should also remember that a foreign corporation authorized to transact business in the Philippines shall obtain an amended license, first in the event it changes its corporate name, or second, desires to pursue other or additional purpose in the Philippines. So if kanang maabot ang time nga ang corporation is kanang gusto nila mag-change og name sa ilahang business, then they should follow these steps, or they should follow these rules. And if gusto sila mag-add additional purpose sa ilang business, or gusto sila mag-extend sa ilang business, then they should follow these rules. So next is section 145, merger or consolidation involving a foreign corporation license in the Philippines. One or more foreign corporations authorized to transact business in the Philippines may merge or consolidate with any domestic corporation or corporations if permitted under Philippine laws and by the law of its incorporation, provided that the requirements on merger or consolidation as provided in this code are followed. So it is clearly stated also in there that what is this merger or consolidation means in connection to the license in the Philippines. So we are now up to section 150, doing business without a license. So what will happen in a business or a foreign corporations without having a license? So it is stated in section 150 that no foreign corporation transacting business in the Philippines without a license or its successors or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines, but such corporation may be sued or proceeded against before Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. So it is really not essential. So there is a general rule in this and exceptions. The aforementioned provisions prevents an unlicensed foreign corporation doing business in the Philippines from accessing courts. So there is also an exception, which is the exception to this rule is the doctrine of estoppel. So next we are up to section 151, revocation of license. So these are the section 151 statement. Without prejudice to other grounds provided under special laws, the license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the Commission upon any of the following grounds. So there are many things we will consider in this as the revocation of license. Some of these are the failure to report an annual failure to compile an annual report and failure to maintain a resident agent, and so many more things we should consider under this section 151. So we're up to section 152, issuance of certificate of revocation. Upon the revocation of the license to transact business in the Philippines, the Commission shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. The Commission shall also mail the notice and copy of the certificate of revocation of the corporation as its registered office in the Philippines. So there is a procedure on how to do this. First is the SEC shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. And second, the SEC shall also mail to the corporation at its registered office in the Philippines a notice of such revocation accompanied by a copy of the certificate of revocation. And lastly, we are now up to withdrawal of foreign corporations subject to existing laws and regulations. A foreign corporation licensed to transact business in the Philippines may be allowed to withdraw from the Philippines by filing a petition for withdrawal of license. No certificate of withdrawal shall be issued by the Commission unless all the following requirements are met. So in withdrawal of foreign corporations, so there are also ways, or there are also things we should met after this withdrawal will be approved. So I think that's all, and I know that you already have read your book, so I don't need to read all these things. Thank you and God bless.